Interesting scenario that hopefully will help a lot of folks. Facts are, mom passed without a will, and her siblings would like to give her the home. How do we do this? Before we get to that answer, I'd like you to imagine a friend of yours going through a troubled time that crept into their lives. But they were prepared because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, so together we can help some folks along the way. First, I would suggest getting help from a probate attorney in your state. You asked that within your question, and it's very important that you have some guidance here. There's a lot to know, understand, and break down. And I'm going to explain a few of those details now. When someone passes without an estate plan, no will, no trust, and they own assets, such as a home, a petition needs to be submitted to the local surrogates court in the county where they've passed for what we call an administration. It's not a probate technically because there's no will. It's called an administration. Now, this, when filed, reflects what assets were held by mom at her passing, if there were any outstanding debts, and the heirs at law. The heirs at law are essentially the closest living relatives according to the intestacy statute of that state. Presumably in this case, we would, if mom did not have a living spouse, let's presume it's you and your siblings. Once someone is named to be in charge of the state and any valid debts are paid and the creditor period has ended, the distribution of the assets can be made. Now, using our example where you and your siblings are the beneficiaries, there are really only two options to alter the outcome on how the asset is supposed to be distributed, right? Because your goal here is instead of it going to you and your siblings equally, is to just come to you. And that's what your siblings have requested as well. So there's only two ways to change that distribution scheme. First, if we are within 9 months of mom's passing, your siblings can file what's called a disclaimer with the surrogates court, waiving their right to the inheritance. And that could be part of the inheritance or the entirety of the inheritance. However, you would need to be certain of the result based on the intestacy law that your siblings saying that they technically predeceased mom would result in that asset coming to you as opposed to maybe grandchildren or something like that. You have to look at the intestacy laws within the state. And this is why I highly suggest that you work with an attorney, probate attorney within your state who's familiar with these laws. The second way to do so, maybe you're outside of the 9 months or the intestacy law, doesn't lead you to the same result, but that is your goal. The second option is for your siblings to gift their interest to you subsequent to the probate process or the administration process. So essentially they would have received it, but then they're gifting it back to you. Now, the impact here is that your siblings will have to file the following April from the year in which they made this gift to you. They will have to file a gift tax return with the federal government. It's a Form 709. There would be absolutely nothing due to the IRS, but it indicates that they've used part of their lifetime exemption in giving that home or their interest in the home back to you. Right now, the lifetime exemption is super high, over $13 million. Not many people are giving away that much or dying with that much. And so it doesn't have a great impact. If either of your siblings do have a sizable estate, then maybe it would. But they would need to file that Form 709 if they're gifting their interest to you in that. In addition, the filing of that gift tax return is required because likelihood is their interest, unless you have a whole lot of siblings, is that their interest that they're transferring to you exceeds what we call the annual gifting allowance, which is only $18,000. So those are really the two options if there's no estate plan and you have to go through an administration. Definitely hire an attorney, though. All right. We hope you've learned something new here today and that you choose to share. And as always, please take care.